Good afternoon, everybody. Can we stay seated for just a few minutes for at least just a couple of quick questions and answers? I'd encourage the students. First of all, my name is Tom Clement. I'm General Counsel for the Michigan Supreme Court. I think what you just saw was very impressive, and I'd like to don't worry about it. Yeah. And I'd like to just acknowledge the hard work that all of these litigants did and the work that they did here today. So if we can give them another round of applause, please. First thing I'd like to do, because we are a little bit short on time and we want to get the reception started as soon as we can, I'd like to give each of these individuals an opportunity, because we have additional people on this side. We have trial counsel and somebody from the State Appellate Defender's Office. I'd like to give everybody a chance to introduce themselves and explain what their role in this process was.
Hi, my name is Daniel Volchak. I'm an attorney in Washington. As I said, I was here representing the American Psychological Association. APA obviously is not a party to this case. It is what's called an amicus curiae, a friend of the court. So we filed a brief in support of the defendant here, and Ms. Murphy was kind enough to offer to share some of her oral argument time. The court was gracious enough to grant that request, that we be allowed time to participate.
I'm Kathy Murphy. I'm a criminal defense attorney in Michigan. I do trial level work in the Wayne County Circuit Court, and I do appeals all over the state of Michigan.
My name is Valerie Newman. I'm an assistant defender with the State Appellate Defender Office. I'm not here on behalf of my office today, though. I wrote the amicus brief on behalf of the Innocence Network and the Criminal Defense Attorneys of Michigan. And if you read that brief, you know we're urging the court to adopt some significant changes in the way eyewitness identification evidence gets admitted into court.
And I'm Patrick Nienhuis. I represented Mr. Thomas at the trial court level in front of Judge Heisey, and I was the one that filed the motions, which later got appealed, and that's why we're here today.
Thank you. And as I make my way over, I just want to point out that there are 2 microphones on either side. So if anybody has any questions, we'd much rather hear your questions than any that I might ask. So please feel free to filter down there.
I'm Jason Williams. I'm an assistant prosecuting attorney in Wayne County. I work for Kim Worthy. I am in charge of the appellate division of the office. My involvement in this case began after the trial judge had suppressed the evidence and dismissed our prosecution. Another attorney in my office is the one who handled the proceedings before Judge Heisey.
Thank you. And just a couple of definitional things. Justice McCormick and Justice Zara both asked you about, quote-unquote, the record evidence. So when you have the microphone, if you could just explain to everybody what exactly they meant by that. And then, Ms. Newman, you referenced an amicus brief. If you could help the audience to understand exactly what that means.
When we refer to record evidence, we refer to the evidence and the pleadings that were presented in the circuit court, which is the trial level court is where witnesses testify and evidence is offered, exhibits are offered, and then that material is then goes with the case to the appellate courts, and the appellate courts generally only review the materials that were presented in the trial court. So when they ask about record evidence, they're referring to the materials that were presented in the trial court.
Thank you. And Ms. Newman. Thank you.
As Danielle said, friend of the court briefs are filed not by the parties, but by people or organizations typically, sometimes people, who are interested in the issue. So I've been interested in the issue of eyewitness identification for many years. I co-chaired a task force for the State Bar that wound up recommending significant changes in the way the police do eyewitness identifications. And by the way, none of those procedures were followed in this case. And it's something that 80% or more of the police jurisdictions in the state of Michigan have adopted. And those changes have been made and adopted to make this process more fair. So this is an issue I've been interested in for a long time. When I follow, as an appellate lawyer, I follow the cases where the Michigan Supreme Court has agreed to hear the case. And so as soon as I saw this leave grant, I looked up who the attorney was. I saw it was Kathy, who happens to be a friend of mine. I reached out to Kathy, I reached out to the Innocence Network, who agreed to come in with us as friend of the court with the Criminal Defense Attorneys of Michigan. And the Innocence Network then reached out to the American Psychological Association, who also agreed to write their own amicus brief on behalf of Mr. Thomas, because this really is a very significant issue. There's big changes going on across the country, and we're hoping we can bring Michigan along on those changes. Yes, either side. You can submit an amicus brief. You're a friend of the court, so you can submit anybody could have submitted a brief on behalf of the prosecution to say that what happened in this case was perfectly reasonable, and they, you know, but very often they're submitted, at least in criminal cases. Well, that's not true. They're submitted on both sides in many cases.
And so we have a unique circumstance here today in that we have, at least on the defense side, we have trial counsel with us. And oftentimes at the Supreme Court level, what we see is we'll have trial counsel, those who argue and will actually try a case, and then when it goes through the appellate courts, you'll have a different counsel and you'll have appellate counsel. For example, you didn't argue the suppression motion, correct? But you're serving an appellate counsel. So I'd ask Mr. Nienhuis, did I say it right? Close enough, okay. If you could just explain to the audience what the nature and the feel of the suppression hearing was. And perhaps balance it out a little bit.
Okay, so at the suppression hearing, both the APA, Mr. Matt Penny, and myself filed briefs on whether or not the motion or the identification should be suppressed. Because like you know, they held that one picture up on a cell phone. And then we went through and found local, you know, Michigan case laws in some Supreme Court cases and argued that. And the judge would, after we took the testimony of what the witness said, she started asking us questions about how each factor, how we can argue based on the testimony, what each factor goes in favor of. I think it was Stowell versus Dental. That's the case that she really wanted to hit on and asked us, like, how does each of you, Mr. Penny and myself, describe how each factor goes into the actual decision that she should make? And then after that, she, you know, took about a week or so, 10 days to make her written decision, and then she gave that to the trial court, or she published that, and after that, the case was dismissed for Mr. Thomas. And Mr. Penny, you know, he had to, it was the prosecutor, sorry, he had to put on the witnesses to show that it was not suggestive, and so he was the one that supplied the officer in charge on the case, the witness, and I think it was Mr. Dykes who was seeing the picture.
All right, I'm going to stop there so that we can get to the reception. I understand that the justices are waiting for us.